Hi, Linda, you ready to go?
I am.
Go ahead.
So, good morning, everyone. This is Linda Spencer. I'm the Director of International for SEMA, and want to welcome you to this, the 5th session that we're hosting on export best practices. Really excited today to have a very great group of panelists. They are IP attachés around the world. And I'd like to introduce in a second Daniel Ingber, who's SEMA's Vice President of Government and Legal Affairs. But I did want to mention that all of the recordings from this session, as well as the other seminars that we've been doing, the online seminars, are available at sema.org/international. And whenever there's a PowerPoint presentation, there's a short one for this session. It's also available at sema.org/international. So thanks again for joining us. Thanks to the Department of Commerce for joining us and helping us with each of these sessions. And now I'd like to turn it over to Daniel Ingber. Daniel.
Hi. Hi, my name is Daniel Ingber. I'm I run the Washington, D.C. office for SEMA, the VP of Government and Legal Affairs. And I'm really pleased to introduce this panel today. These are IP attachés with the U.S. government and part of the IP attaché program at the U.S. PTO. And they are the principal officers within embassies and consulates throughout the region related to protection of IP rights. We have 5 panelists today. The first is Dominic Keating, who is the director of the program from including Beijing, Guangzhou, Shanghai, Rio de Janeiro, Lima, Delhi, Geneva, Bangkok, Kuwait, Kiev, and Brussels offices. So he's basically a worldwide organizer of the IP Attaché program. And then we'll have John Cabeza, who represents the India region, Southeast Asia, which serves also Afghanistan, Bangladesh, Bhutan, India, the Maldives, Nepal, Pakistan, Sri Lanka. We'll have Peter McRovery, who is based in Kuwait and represents the Middle East and North Africa regions. Duncan Wilson, who's based in Beijing, who is helping protect rights in China. And then Conrad Wong will be on our panel for questions, who also represents Southern China and Guangzhou. So there will be there's a question box in the lower right where you can ask questions throughout the webinar. You type them into the box there. It should be on the bar on your right, and we will address those questions at the end of the webinar. So it's my pleasure to introduce Dominic Keating.
Thank you for that, Daniel. It's a pleasure to be here and to join you today. I think this is a wonderful opportunity to talk about the IP Attaché program and for you all to get to know some of the IP Attachés. As Daniel mentioned, the IP Attachés are the principal officers on IP at the embassies, U.S. embassies around the world. We have 13 active IP Attaché posts scattered around the world. You can see them on the screen here. And an important point about the attachés is they're generally regional in coverage. So if you look at this list, Brazil covers a large region. Our Brazil office, who is headed by Beatrice Delore, who's our local IP specialist, she covers a region which is essentially the eastern side of South America. And then on the other side of South America is based in Lima, Peru, Ann Chadovitz, who covers the other side of the continent. And then in Mexico City, we have Cindy Henderson covering Mexico, Central America, and the Caribbean. In Europe, we have Susan Wilson covering essentially all of Europe, all of the EU. And then we also have 2 people in Geneva, Switzerland, Debbie Lashley Johnson working on issues at the World Trade Organization, and Christine Schlegelmilch working on issues, UN issues, including those at the World Intellectual Property Organization. So those 2 are focused on multilateral issues and not a regional focus, but the other is regional. In Ukraine, we have Dorian Mazurkovich working on everything within the region of Central Eurasia, which covers Russia. And then, as you've heard, Pete Maraveri is based in Kuwait City. He's covering all of the Middle East and North Africa. You've heard that John Cabeza is in New Delhi. He's covering all of South Asia. Kidasi Sukapinda is in Bangkok, covering the entire ASEAN region. And then, because of the importance of China, we have 3 IP attaché positions there. 2 of the attachés are on the call with us today, Duncan, who's based in Beijing, and Conrad, who's based in Guangzhou. We also have Erin Shi based in Shanghai, or heading up that office for now. And she's our local IP specialist. And I mentioned the word specialist. We have each of the attachés has a team of local staff working for them. These include local IP attorneys or IP specialists, and they also have teams of specialized IP attorneys back in USPTO headquarters. So a lot of resources to work with and support them. What do the attachés do? One of their essential roles is to help US businesses and other US stakeholders. So SEMA members, if you run into trouble, please go and talk to your local IP attaché. They can provide valuable information about IP issues in country or in a country or region. They can sometimes help you to identify points of contact within the host governments. They can sometimes make introductions to those points of contact, and at times they can advocate for you advocate for you to address particular systemic IP issues that you may be faced with. Their advocacy is even more macroscopic at times. It's done on a wide range of issues that are important to the United States government and US industry. The attachés sit down with their host government counterparts and talk about these issues on a regular basis. They also train foreign government officials on IP matters to help them to be more effective at what they do with respect to IP. And they help the public to understand intellectual property, why it's important, and why it should be enforced through IP awareness programs. So that's all I'd like to mention for now, but I'd like to leave you with the fact that you can reach out to any of the IP attachés at any time. All of their contact information is on the USPTO website at uspto.gov. Thank you.
Thank you, Dominic. We appreciate that very much. And next, I'd like to introduce John Cabeza, who represents South Asia and is based in India.
Okay, I believe I'm unmuted now. Hello, and good morning, afternoon, and evening to all of you. It's a pleasure to be here. I'm actually excited to speak with you today. Linda and I were talking before we all joined about the annual SEMA show in Las Vegas. And prior to assuming the role as the IP attaché in New Delhi, I was the USPTO's regional director covering the West Coast. So Las Vegas and Nevada was in my territory, and but unfortunately never got to go to the SEMA show, although that is something I hope to do one day. Although I did get to go to the Consumer Electronics Show, and the Automotive Innovation Wing was always something I would geek out over every year. So I can just imagine what the SEMA show was like. So that was in a former life, in a former position, and fast forward a few months, I'm the newest, I believe still the newest IP attaché, and based here in New Delhi, India. And I started here just a few months ago, so still learning the landscape and understanding this very complicated network of issues across South Asia, and primarily focused in India. And as many of you might be aware from your own experiences, the IP landscape in India can be quite complicated. The good news is there's been some efforts in recent years, and a lot of goodwill at the highest levels of the Indian government to strengthen India's IP laws, and so that showed a lot of promise. And those efforts are for sure to be commended. And at the same time, though, India remains one of the most challenging jurisdictions to obtain and enforce your intellectual property. In fact, India remains on USTR's Special 301 priority watch list for intellectual property enforcement due to the significant difficulties US industries face enforcing their rights in India. So while it's complicated, it is complicated across industries, including for automobile and auto parts manufacturers. So tonight, or today, or this morning, one of the things I would like to highlight for you are three things that I think are most relevant to SEMA and its members. And first, as it relates to patents, India has something that I have found to be quite unique. I'm not sure if other patent offices do this. I'm not aware of any, but they have a working requirement. And this working requirement, basically, it's not enough just to get a patent for your innovation in India. You also have to work that patent and are subject to reporting requirements annually, where you have to certify the extent to which the patent is being worked. And failure to work your patent in India is a reason, can be cause to have that patent invalidated. So, while from an enforcement perspective, it's always important to, obviously you need to get patent protection to enforce your rights in the territory where that innovation is patented, but that's not enough in India. You also, in addition to getting the patent, have to demonstrate that you are working the patent. And so this has been an area of a lot of debate, and the US, along with numerous industry groups, from high tech to pharmaceutical to device manufacturers, have all raised concerns requesting some clarity as to exactly what's required in this Form 27 reporting requirement. And India has been taking some positive steps in that direction to help bring some clarity. And one question, for example, is importation of the product into India sufficient to demonstrate a working requirement? And again, these issues are still up for much debate. So, so as you embark on as a territory from a trademark perspective. Was there a question?
Oh no, John, your cell phone was breaking up.
From a trademark perspective, one of the things I just wanted to highlight is, oh, okay. Can you hear me now?
Yes, it's better now, it seems.
Am I audible now? Okay.
Yeah, it sounds like it's better now.
Now you know why I'm not on camera. So I've been having network issues.
No worries.
Okay, good. So it's actually the middle of okay, good. Hopefully you can hear me. So we're in the middle of monsoon season, so the internet connectivity has been quite spotty these past few days. So I apologize. So turning from the working requirement in patents, I just wanted to speak briefly about trademarks and brands. One of the things that India had taken some initiatives towards was bringing down their trademark examination backlog. And they seem to have done that significantly in a very short period of time, which has led to a lot of trademark registrations, which has then also led to a lot of opposition proceedings. And unfortunately, the opposition proceedings, questioning the quality of the registrations, opposition proceedings take a much longer period of time to resolve. And given the backlog of oppositions, it's taking much longer these days. And just in the interest of time, I wanted to quickly touch on enforcement. Although it's a good thing that the China team is going last, because I'm sure they'll have a lot to share on this as well. But from what I understand in speaking with members of the industry here in India, is we're still seeing a significant number of counterfeit products on sale in India that are still originating from China. But with that said, the manufacturing capacity of these products, of replacement parts and other parts, and is in India anyway, is growing. And it's at the same time, while we recognize a large number of OEM parts are not protected under patent in India, which obviously, if you don't have the patent in India, you can't enforce your rights in India as it relates to patents anyway. And so what we're seeing is with respect to the automotive industry that I've spoken to in recent years, they've been re-strategizing with respect to their portfolios in India, and have been, over the past handful of years anyway, increasing the number of patents they've been filing so that they can, if needed, enforce those rights to address the counterfeit goods showing up in the market here. Also, on the enforcement side, I think it's also important to know that in India, India does not give patents a presumption of validity like we see in the United States. And so as a result of that, there's always this threat that complicates the value and the security of the intellectual property. And then along those lines, in obtaining your patent, India has something called pre-grant opposition. And what we're seeing, while we see this mostly in the pharmaceutical space, we see it in other industries as well, where serial filings of these pre-grant oppositions actually prevent or delay for years the issuance of a patent, and also can yield great expense to the right owner. Again, we're seeing it as a strategy in the pharmaceutical space, but at the same time, it's a strategy that could be employed in any industry. So it is something to be wary of. And then lastly, I just wanted to share, as it relates to the courts here in India. I mentioned earlier that we've been seeing some progress, and back in 2015, there was a passage of the Commercial Courts Act, which provided an opportunity to reduce delays and increase expertise in the judicial matters as it relates to intellectual property. So that was definitely a positive step forward. However, it's only occurred in a couple of instances, which has led to other challenges, such as jurisdictional challenges, that has reduced the effectiveness of the intent of this act. So that's another thing that we continue to work with the government of India on. And then, and I know I'm running out of time, so I'm just going to skip to kind of the final point here. And when it comes to the automotive industry, usually we see counterfeiting as a concern for the multinational corporations and for the auto sector as well. But in the auto sector, we see it's also a big issue for the Indian industries. And so we've seen a lot of the Indian automotive sector being very vocal about their ability to enforce their rights in India, which is a good sign as well. And it's something that we're looking to partner with them going forward. And then lastly, in closing, just for your awareness, there are two industry-focused associations that work on causes for the automobile sector here in India that might be good to partner with in future programs. And that's the Society of Indian Automobile Manufacturers and the Automotive Component Manufacturers Association of India. And with that, I thank you all very much. Again, apologies for not being on camera, but look forward to the ongoing discussion. Thank you.
Thank you very much. Really appreciate that, John. Next, I'm very pleased to introduce Peter Moravri, who's based in Kuwait City, where I think 3 days this week are going to be above 110 degrees. So, you may be hot in New Delhi, John, but you got nothing on Peter. So it's my absolute pleasure to introduce Peter.
Thanks, Daniel, for the introduction. And yes, it is quite hot over here in the Middle East, but after about almost 2.5 years here, I've survived now 3 summers in the Middle East. So I'm getting slowly used to it. I'm a little worried about coming back to DC and just snow, but for now it's been great out here. I will say one of my first experiences coming out to the region was doing an IP forum at the SEMA show in Abu Dhabi with Linda and Liz, and had a fantastic time. And we talked with a lot of startups about protecting their parts. But my favorite memory was I thought that I could drive a go-kart, and then when I hung out with all the SEMA folks at the show and just got destroyed on the go-kart race, I learned that I was way out of my league when it comes to the amazing talent and parts that these companies are putting together. And I think from then, my whole level of respect just for that industry just rose. And now it's been a big passion of mine to really make sure that those companies are protected out in the Middle East, North Africa. So again, just like John, I have 3 points I wanted to share. The first one is really more about just business generally in the Middle East and North Africa. It really used to be a safe place for US companies, especially SMEs, to come and get a local distributor and have a local distributor that's been a trusted partner for years and years and years. Unfortunately, what we've seen happening is as the oil prices went down, the countries in the region really changed their attitude about what was important. And we saw that countries were creating these visions. These visions were trying to put in place to increase the private sector and really encourage innovative and creative companies to either enter the markets here or be creative from the local economy. What we saw happen was one of the shortcuts that some of the local companies were taking was to take some of their partners that they've been working on with for a long time and stealing their businesses and thinking that was a fast track. And the problem was a lot of US companies have been doing business in the region for many, many years and had not protected their brands or their designs or their inventions because there was no need at that point because there was not a big threat. But all of a sudden we started to see counterfeits pop up, and again, not just from multinational US companies, but from SMEs, including in the auto business. And that was sort of a red flag about 2 years ago. And one of the things I would highly recommend is that if you've been doing business in this region for many years, please make sure that your brands are registered. Please make sure your designs are registered. And if you have inventions, please make sure you're patenting those as well. Because right now there is an attack on innovation and US companies because of the amazing quality parts that we are bringing into the region. I can't sort of tell you the number of horror stories I have about getting calls late at night from US companies, including the auto business, that say, hey, Pete, we just saw for the first time counterfeit exhaust systems coming into UAE. We don't have our trademarks filed because we've never needed them to, and we don't know what to do. And at that point, it's sort of a triage effort to figure out what's the best way forward. So my first piece of advice is if you're doing business in the Middle East, please, please, please make sure that you're protected before coming out here. And if you have been doing business in the Middle East for a long time, please, please make sure that your brands are registered and that you have the ownership of those marks. We've seen in some cases the local distributor transferring the ownership of trademarks, designs to the local company, and then will stop the legitimate parts from coming in through customs. And it's happened about over 10 times in the last 2 years. So please be careful with that. So I know I kind of scared everyone, but I wanted to talk about some good news. The good news is that we are seeing an increase in the IP enforcement in the region. One of the biggest success stories I'd say right now is in Saudi Arabia, where the Saudi government created a new authority, the Saudi Authority for Intellectual Property. This is the first ever consolidated intellectual property office in Saudi Arabia that not only does protections, you can file your trademarks through them, your designs, your patents, all through one agency, but they also help coordinate enforcement. There's even a button on their website. It's www.saip.gov.sa. There's a button that says file a complaint. You can submit a complaint via email about having infringing parts or counterfeit parts somewhere in Saudi Arabia. You provide documentation of the things and send an email. And usually in a couple of days, you'll get a response back and they'll start working with you to figure out how best to enforce your rights out in Saudi Arabia. Similarly in UAE, after many years of sort of not really taking a serious stand on the extreme amount of counterfeits that were being transshipped through Dubai or even leaking into the markets in UAE. Over the last year or so, we've seen the UAE authorities start taking it more seriously. We've seen an increase in seizures, destructions, and not only that, but attention by the federal government to really make a change within the entire UAE. So that's a bit more good news. But the last part I want to talk about was what's the best way and best practices to really use, I'd say me, but most of the attachés also. And one thing that we can do is help with accountability. Is that if you see infringing goods in the marketplace, my best advice is to first make sure that you follow the government regulations about how to file a complaint. But once you do that, please let us know immediately, because then we can follow up through our back channels with the different enforcement agencies in the countries we work with. And we can say, you know, look, the US Embassy, the US IP Attachés are following this case and want to make sure that the process is done correctly and at a fast pace. And the example I'll give is actually in Kuwait, where we had a US company, a SME, and they tried to file a complaint against a shop selling counterfeit products. And these are pretty dangerous counterfeit products. So it wasn't just like a purse or a bag or a shirt, it was a mechanical part that, if installed incorrectly, could have serious damage, and this was a counterfeit part. So they tried to file a complaint with the government, and that complaint never went through. They contacted me, and I said, okay, let's do this together. So we contacted the government. We told the government that we'd be meeting in their office at, I think it was 11 o'clock in the morning on a Tuesday, and to file the complaint together. So we got to the office, we waited an hour, 2 hours, and finally they came, we submitted the complaint, and we thought we were gonna get a raid done. But no, it took a few more days of us going back to the office, for me sitting in their offices until it's got done, but eventually we got the raid done. And that's one thing that we can do, is we can help make sure that if you're going through the right process that that country has in place to enforce your IP rights, let us know, because we want to be there. We want to make sure it happens and it works. So I think with that, those are the 3 points. 1, make sure you're protected before you go in. 2, there is some positive developments happening in the Middle East with new offices and new procedures. And 3, please use us, because we are here to help you, especially for startups, SMEs. This is one of the things that we take very seriously to make sure that your rights are protected throughout the world and the region. Thank you.
Thank you, Peter. Thanks a lot. That was an excellent presentation. And you know, as we know, the Middle East is a very important part of the aftermarkets industry, and there's a lot of export opportunities there, and it's important for our members to understand the challenges and the opportunities there. So I'm very pleased to introduce Duncan Wilson, representing Beijing. China doesn't really come up much in IP issues. I'm just joking, of course. It's a front and center. So go ahead.
Great, thank you very much, Daniel, and thank you very much to SEMA for having us here today. China obviously is pretty well known by many manufacturers for the IP issues. So today I'm going to just provide a brief overview of IP protection enforcement issues, highlight some best practices and key points in regards to specific rights and enforcement channels. But I do want to leave time for questions for companies that may have more experience in China or be dealing with a specific issue to be able to address those questions. So just to start out, I want to reiterate that I'm joined today by my colleague Conrad Wong, who's based in the consulate in Guangzhou with responsibility for Southern China, as well as Hong Kong, who is an excellent resource, a legend in Southern China, and a legend along the East Coast with all classic automobile dealers. So Conrad has got a lot of experience in this industry, so I look forward to his comments and responses to your questions as well. You know, for those who aren't reading the newspaper or the president's tweets, you may not be aware, but China is a very high threat environment for IP infringement. And IP infringement really is not a matter of if, but when. And unfortunately, for a lot of individuals and companies operating in China, infringement is a legitimate form of business. And so for small and medium-sized enterprises, presents a real challenge, because we can advise you to register your rights, whether they're trademarks or patents or whatever, but you do need to think about the enforcement of those rights because of the high likelihood that you'll need to enforce your rights. And so things like budget for investigators and for lawyers and for other agents are part of the strategy that needs to happen in China, as well as a very broad kind of multifaceted IP portfolio, not just a trademark, but also maybe copyright, maybe designs, and we'll talk about trademarks and designs in a little bit. But be aware that given this high threat environment, you need to think very creatively within budget, of course, about how to both protect, but also get effective enforcement in China. So anyway, I want to jump right in talking about trademarks. Trademarks, I'm sure you know, are territorial, so your US trademarks are of no value whatsoever in China, as well as the fact that China is a first to file jurisdiction, as actually many jurisdictions in the world are, but not the United States. So whoever files first in China is going to get that trademark, regardless of any use in China generally, and certainly regardless of any use in the United States or in other markets. And so it's absolutely critical that you get your marks registered there early. And in China in particular, we've had for many years now, over a decade, I would say, the problem of what we call bad faith trademarks, which is companies or individuals filing for the trademarks of others and registering those trademarks. And this is a particularly big problem for SMEs because oftentimes they'll get to China, try to register their rights, and realize that someone else has already registered them for themselves, and it's very expensive and time-consuming to get it back. So in China in particular, if you're manufacturing there, most definitely, if you're selling there as well, you want to register your rights as early as possible, preferably before you enter the market, even before you have discussions with potential distributors. And I'll get to potential distributors in 1 second. The next point I want to make is that China has this incredibly complex subclass system that I'm not going to go into at all. But if you are discussing with a lawyer or a trademark agent in China your trademark and how much you want to cover, you need to be aware of this subclass system because it determines kind of the scope of your coverage in a way that's very different from the United States and other jurisdictions. And so while I'm not going to get into detail, and of course I'll answer questions, if you're having those conversations, raise the subclass system, make sure you're covered in appropriate subclasses in China so that you can stop the counterfeits and infringements when they occur. One thing to do is to consider adopting and registering a Chinese language trademark. And this seems like a little bit of a hassle, but the fact is that most Chinese consumers are not going to be able to pronounce your English language brand. And what they're going to do is they're going to create their own transliteration or homophone of your mark, something that sounds like your brand, but in the Chinese language. And they're going to use that. That'll happen as a natural consequence of hearing the brand. And what happens in certain cases is that other people register the Chinese language brand that has been developed by the consumer. And then that prevents you from using it, you from using the name that most Chinese consumers use to refer to your product. And so that can be a really big problem. So it's best really to come up with your own, register that, and then Chinese consumers will immediately adopt the one that you already have protection for. Finally, I want to say, related to the point of distributors, never and under any circumstances, although I'm sure you can find exceptions, but generally never allow your business partners or distributors or licensees to register any of your intellectual property in China, and certainly not your trademarks. What we see over decades is that oftentimes US companies will rely upon their distributors to register their trademarks or not even be aware that the distributors are registering their trademarks. And when they go to register, the distributor will say, well, I already registered it. I did it for you. You know, I did it for our business. But then when the rights holder, the US company, wants it back, the Chinese company refuses to give it back, unless maybe they sign like a 10-year distribution deal. So they use it to leverage to gain leverage in negotiations with the US company. Or they just say goodbye and just produce your product, and they have the authorization to do so in China, and they can export it around the world. So do be aware that you have to be very careful with your business partners in China, in particular in regards to the registration of trademarks and other intellectual property. Moving on to designs, I want to talk about design patents very quickly. You know, China has 3 types of patents, and the United States only has 2. So for a lot of companies entering the Chinese market, they're not aware that there are things that they might be able to patent in China that they can't patent in the United States. So China has what they call the Invention Patent, which is similar to what we call the utility patent. It's kind of your traditional patent covering like a formula or a process, a compound. But in addition, they have a design patent. Now, we also have something similar called a design patent, but China has it too. It's to cover a shape or a color or a pattern or a combination of these these things put together. And like I said, it's similar to the US design patent, but in the US, this design patent, is protected for 15 years. In China, it's only 10. So be aware that there's a different term of protection in China than the United States. Also, I want to point out that the third type of patent that we don't have in the United States is called a utility model patent. And that type of patent protects a product's shape or physical features. So that can be another valuable patent that you can get in China, in addition to the design patent, that might be able to protect your product. Now, both the design patent and the utility model patent are granted, in most cases, about 80 to 85% of cases, it's granted without any examination. And so what that means is, for you, is that you're able to get a patent, a design patent for your design, or utility model patent for the product shape or physical features within 11 months. And so, or under a year or 8 months, it can happen very, very quickly. So that can be a means of getting rights very, very quickly in China. It's becoming a little more difficult now, but still, relatively speaking, it's relatively simple. Of course, these are all patents, so they all need to be new. You can't file old designs, although I guess you could because they're not examined, but they might be invalidated when you try to enforce them. The design patents are really just one way of protecting designs in China. We being the Chinese, also protect designs through three-dimensional trademarks. You can apply for a product shape or a product packaging as a three-dimensional trademark. Generally, those are very difficult to obtain, but it is possible, and enforcement is relatively easier than other design rights. As well, you can apply for copyright as applied art in China. And another way to do it is through China's anti-unfair competition law. Now, this is an unregistered design right, and you need to be able to demonstrate that the design that's been copied is both distinctive as well as pretty popular in order to get this protection. But over the past few years, actually, there was a very high-profile case in China that just came to a conclusion last year involving Land Rover, which you might be aware of, where it was faced with a local competitor that had copied its vehicle design. And both the local competitor and Land Rover actually obtained design patents for the design of the vehicle. But both of those patents were invalidated by the Chinese Patent Office. And what happened was Land Rover sued this Chinese competitor using the anti-unfair competition law, this provision that protects distinctive designs, and was able to be successful. So again, as I mentioned at the very beginning, it's very important, given the high threat of infringement, to be aware of all these opportunities, or I wouldn't say opportunities, all these options for protecting your designs and brands in China. Speaking of brands, I just want to highlight very quickly copyright. Oftentimes people think of copyright as only protecting books or movies or films, but in China, copyright can be a very valuable anti-counterfeiting and brand protection tool, because in China, oftentimes infringers are very greedy, and they don't want to just infringe your name. They want to infringe your posters. They want to infringe your whole website. They want to infringe all your manuals. They want to infringe everything. They basically rebuild your business in China. And so you can use copyright to fight back against those wholesale copyings. And fortunately, both the United States and China are both members of the Berne Convention. And what that means is that anything that you create in the United States that is protected by copyright is also protected in China. So you do have to go through the process of enforcing it, but in terms of having that copyright, you don't have to register it in China in order to have that protection. It's automatically granted. I do want to talk now very briefly, I know I'm running out of time here, so I apologize, about for enforcement of IP in China. And for those who are not familiar, in China, there are essentially three primary channels to enforce your rights in China. Excuse me, administrative enforcement. I'm sorry, it's gone. Okay, administrative enforcement, civil enforcement, and criminal enforcement. And administrative enforcement, one of those options that we don't have in the United States that rights holders who are new to China might not be aware is an option for enforcing IP. Essentially, it's filing a complaint with a local administrative office. And you'll find these all over China. In every city and in every district of major cities, there is going to be this administrative office for filing this type of complaint. And any IP right can be enforced through this administrative channel. And you file a complaint, they accept the complaint, hopefully, they carry out an investigation, they can seize product, they can seal up a store, seal up a factory, they can destroy goods, they can issue a fine, and they can issue an injunction. And generally, rights holders like this enforcement channel when the infringement is relatively small scale, because this is a very quick and cheap enforcement method. But the penalties are so low, and I just mentioned the injunction. That injunction that stops the infringement is only valid in the district where this administrative office sits. So you're unable to stop the infringement from popping up in another district, or if you get it from the city in another city. So it's really a very limited enforcement remedy in China. Customs enforcement, though, is a form of administrative enforcement. That's enforcement at the border. You're probably aware that the vast majority of the goods that are seized at the US border that are infringing come from China. About 85% of all the infringing goods come from China or from China through Hong Kong. But in China, customs enforcement, it's a little different. The vast majority of IP enforcement with customs is on export, not goods coming into China, but perhaps not surprising, the goods coming out of China. So customs enforcement can be a very important component of an overall enforcement strategy. If your rights are registered in China, you can have customs seize these goods on export. They'll ask for a verification from the rights holder. They generally want the verification very quickly, within a few days. But if they get the verification, then they can proceed with a punishment decision. Again, they can issue a fine or destroy the goods as a result. I do want to point out that customs, if you register your rights in China and then record them, customs will seize goods on your behalf without you having to ask for it. But this generally requires have a good relationship with customs, working with them to understand and how to spot the infringements for your products, understand where your products are coming from. So while that's a very valuable enforcement option, it's not necessarily one that's kind of automatic. It does take a bit of groundwork. I do want to point out in the limited time I have here, a very troubling development that we've seen in China, which is similar to what Pete kind of mentioned. What we have seen is that because companies are able to register US brand names in China, they've been very active in the last 2 years, seizing US products on export to the United States. So before the products leave China, they get seized at the border. And we've seen several small and medium-sized enterprises brought to their knees because all the products have been stopped and they've been unable to do business. And unfortunately, this problem is getting worse, and it just highlights the importance of registering your trademarks in China, certainly if you're manufacturing there, to ensure that you can ensure the free flow of goods. And previously, companies weren't really concerned about that, but the rules in China have changed, and you need to absolutely have that mark, that trademark registered in the United States in order to be able to export. I do want to leave time for questions. I kind of left off civil enforcement and criminal enforcement through the courts and through the police. I'll just say very quickly, civil enforcement is improving greatly in China. The judges are more professional. Cases move quite quickly. They move much more quickly than the United States. You can generally get a judgment within 6 to 9 months. You get damages, higher penalties than with administrative enforcement. Criminal enforcement, even higher penalties, higher fines, potential of jail time. But it's very difficult to get the police and the prosecutors to take your case. And generally, you have got to do a lot of the groundwork and investigations in advance and bring it to them as a complete case in order for them to take it. And even after that, you sort of lose control of the case as the prosecutors and police decide what exactly they're going to do with it. So all those enforcement channels have their pros and cons. And I didn't have a chance to get into all of them, but I do welcome your questions. Thank you very much.
Thank you very much, Duncan. That was very interesting, and obviously China has proven to be a challenge for our members for going on decades now. So it's been it's obviously a very important market. So I'm going to turn to some questions now that we have. First question I have, I'm going to gear towards this is really for I'm going to gear this for Dominic because it's more general, but the question was, our distributor has offered to register our trademark for us. Is there a downside for accepting that offer?
Yes, I mean, I think each of the attachés would want to follow up on this, but I think if you have a foreign distributor that wants to register your trademark, you're trusting that that's the ownership of that trademark is somehow going to be assigned to you. And I think there's a tremendous amount of risk there. And I think Duncan, for one, and probably others on this call would be able to tell you stories about how that has gone very wrong for U.S. rights holders, where their foreign distributor has registered a trademark supposedly for them, but it ended up being really for the foreign distributor, and ultimately they might have been sued by the foreign distributor who took over the trademark and operated independently in that market. Daniel, is it okay if we hear some comments from the attachés?
Well, of course, yes, I think that's important, especially because this is an area where you're kind of ceding control a little bit, which would not, in some cases, can be a bigger pitfall. So why don't we go to Duncan to talk about China first with that, because I think that's some interesting territory.
Yeah, I think I mentioned during my presentation, maybe twice, the importance of not allowing the local distributor to do that, and the problems that might result from that, from blackmail to say the production and sale of products bearing your marks and export to other markets, including the United States. It never does end well, and I do have a lot of stories. Of course, I can't go through all of them right now, but it does happen a lot, and I think U.S. Chinese companies operating are kind of used to the naivete, unfortunately, of U.S. companies. Are very trusting. Companies tend to be very trusting. U.S. companies tend to be very trusting of their business partners, and Chinese companies know this, and they also know that U.S. companies tend to think of China as this sort of, oh, it's so foreign, it's so opaque, like I could never understand it. So I need to trust that business partner to do everything for me. And frankly, it is a very challenging environment, but there are laws, they are public, there are courts and everything. So there are mechanisms that you can use to enforce your rights. So I think it's important to be more proactive, much less trusting, unfortunately, when you're operating in China. I know I just spoke for a lot, but I did want to give Conrad a chance to respond if he had any comments on China, since he didn't have an opportunity to speak earlier. Thank you.
Sure, Duncan and Daniel and Linda, thank you very much for arranging all of this this morning for us to speak to your members. I wanted to just add that it's very important for members not to go on autopilot, even if they're a small business, particularly in China, but I would say this is probably the same for India, the Middle East, or wherever you're operating your business or having goods exported. Particularly in China, I think going to the issue about trust and saying, oh, well, I met someone his name is Steve, and he speaks very good English, and he's been great, and I've sort of more or less entrusted everything to him. That is a very, very serious mistake. It's incumbent upon the member or the owner of the business to check on what's going on overseas. You cannot be too trusting. We've already heard already about the issues of distributors or partners sort of taking over the ownership of the marks, thinking, oh, I'm just doing this for you and it's for your benefit. But unfortunately, they can go rogue. So it is important for the business owner to periodically go over to China when I hope we have established air links again, but to just drop in unannounced and say, hi, I'm just here to check on what's going on over here and to renew my business ties. I happen to be coming through. I want to speak to you. I would not give any kind of advance warning. I would just go ahead and come in. If it's possible to maintain someone that's on your company payroll of your company, have that person on your payroll to check on what's going on with your operations overseas. So that's what I would suggest for the moment. So thank you.
Thanks, Conrad. Appreciate that. I'm going to move on from that question because I think that's similar advice that would work for the other regions as well. I have an interesting question. My distributor has informed me that counterfeits of my product are being sold in Kuwait. The products manufactured in China include our branding. Do I fight this infringement with Chinese officials or Kuwaiti officials? I understand that Kuwaiti officials have not been very aggressive in enforcement removing counterfeit products. Do you see that changing? And then they were also asked about bad faith trademark filing in China, which we've discussed a little bit. But so I'm going to let Peter address this first, and then I'll have Conrad and Duncan chime in, if that's okay.
Thanks, Daniel. Yeah, I mean, if this was maybe 2 years ago, I would say, it's not going to happen in Kuwait. But over the last about year and a half, the Kuwaiti government has taken enforcement a bit more seriously. We've had about 5 or 6 successful raids done last year alone. With COVID, things have slowed down a bit in Kuwait just generally. But I definitely think right now is a good time to do IP enforcement actions in Kuwait, and especially on auto parts, because the Kuwaitis love their cars, love their vehicles. And I think that could be definitely a good opportunity. So please reach out to me, and maybe we can talk through that process in depth.
Great, thank you. And then Conrad or Duncan, do you want to chime in a little bit about that as well?
Conrad, do you want to start?
Sure. Just to the enforcement the issues that Duncan has already outlined, it is very important to work with folks on the ground here. If you have an investigator, perhaps someone who can be looking into on your behalf as to the extent of the copying, where it's occurring. That's very, very important, whether it's in Guangdong province here in southern China or up in northeast China or wherever, because the enforcement aspects are going to be much more local. So it's very important to build relationships with the local public security bureau, which is China's National Police Service. As Duncan has already indicated, it's important to build relationships with the local customs branches where your goods are being exported, whether they're being exported out of Shenzhen in southern China or in Tianjin up in northern China near Beijing. So these sorts of relationships and working with investigators and building a case are extremely important. And as Duncan also has indicated, it's very important to sort of wrap everything up as a complete package so that you can give everything to the Public Security Bureau, and then they, go ahead and or the Customs Service, and then they go ahead and present that if it becomes a criminal matter to the Procuratorate, which is China's National Prosecution Service, and then that way they can pursue possibly a criminal IP investigation and prosecution. Let me turn it over to Duncan for additional comments.
So if you don't mind, Duncan, I just want to kind of keep this going a little bit, and I think that's helpful, and it dovetails with questions we've gotten in specifically about several regions. So first of all, a question, UAE, which I know has had very notoriously high costs for registration, and doing business there is one of the issues. And then we had also had a member ask, what if an infringer makes a claim of prior art in China that's bogus? U.S. law firms are very high prices to combat this. They kind of see as a black hole of IP in China there. And then we've also had someone say, I've heard that registering patents in India is very costly and time consuming. So there's questions about whether these costs are going to go down, whether it's going to be more streamlined. So, and it really covers all the regions. And, our members, 90% of SEMA members are under 100 employees, and they tend to be a lot fewer. Even our, our sophisticated exporters are on thin margins, and hiring law firms and doing work in China is pretty difficult. So I'm going to start with Peter, and then talk about UAE, and then we could have John chime in about India, and then we'll wrap up with China.
Thanks, Ian. That's a great question. I mean, and UAE is known for, the tallest building in the world, the Burj Khalifa. It was also used to be known for the highest trademark fees in the world. But this was a big priority for the U.S. government. And we were very successful last summer to reduce the trademark fees by 30%. So they're no longer the highest in the world, but they were still pretty high. The good news is that, again, I would say it's good news because it's sort of connected with COVID crisis, but with the COVID crisis, the Emirati government wanted to reduce its fees even more to support startups in the region. And as of about a month and a half ago, they've reduced their fees on both patents and trademarks significantly. So if you've been looking for a good time to register trademarks and patents in UAE, right now is a very good time to do it.
Great, thank you. Appreciate that, Peter. And then I'd like to turn to John and talk about India and the cost of registration in India, and how we and what your thoughts are, and whether those are changing and how that compares to other regions.
Yes, thank you. And I did try to get on my video, but you saw what happened, that froze, so I'm off video again. So hopefully you can hear me. Again, apologies for that. But yeah, so with respect to the costs in India, they're not exorbitant, I think by standards. The good news here is there are incentives that have been put in place for micro and small entities, a specific incentive that's been put in place for startups as well, and then also something that I believe is in the works for COVID-related innovations. But that said, with respect to the cost and the timeliness, if all goes well, it's not, like I said, exorbitant. But if you're subject to these serial pre-grant oppositions, like I was mentioning before, and you have to fight those battles, and then post-grant oppositions, it can get quite costly. And without having a presumption of validity for patents granted in India, it's always a challenge, and the patents are always at risk. So those things kind of weigh in addition to costs as factors to consider when you're developing your strategy, but yet still extremely important for a market this size.
Thank you. And then Duncan, and as opposed to the cost of registration, could you talk a little bit about the cost of enforcement when it comes to hiring trustworthy firms? And it can be so. And I've heard this time and time again how prohibitive it is for people to defend their rights in China from a cost perspective. So.
Yeah, sure. So I think, I sort of mentioned that up front, is that I think a lot of U.S. companies, especially the smaller ones, don't understand or recognize the costs that come along with enforcement that is almost inevitable in the Chinese market because of the widespread infringement. I think that a lot of companies end up using U.S. firms to carry out their enforcement in China, and those U.S. firms work with local firms, and so you end up getting billed twice. And I was actually at one of those foreign firms. I was an IP attorney at a U.S. law firm in Beijing for 6 years. But that has its advantages, and we can probably maybe have a whole nother conversation about the disadvantages and advantages. But what I would say is that there are many local Chinese firms whose prices are much more reasonable than the foreign firm.
Is that realistic? I mean, I'm even speaking from personal experience, to reach out to a local counsel without first going through your U.S. counsel, vetting them, making sure they're legitimate. Doing that is, I've never done that, and I don't know if most of our members would be comfortable, picking up the phone and calling, for instance, a Beijing-based law firm.
Yeah, I wouldn't recommend cold calling a Chinese firm that you've never heard of. I think that it's very important. You do have to do some vetting. I mean, and certainly a U.S. counsel can help you vet that, and they probably wouldn't appreciate if they vet someone and then you go through them without going through the U.S. counsel to keep that relationship. But there are, rankings of IP firms, both foreign and domestic. Obviously, the highly ranked ones are going to be a little more expensive, but there are a lot of different lists in China or Asia Lawyer. Again, I'm happy to help members try to locate counsel, although I can't make any recommendations about counsel as a U.S. Patent and Trademark Office employee, but I can show you where these resources are, and so it can help you on that journey. And I do understand that the problem you're talking about. It's absolutely an issue, and it can be very challenging to find those attorneys, but they do exist out there. These smaller, mid-sized Chinese firms that are trustworthy and actually quite good. So.
Great, thank you. And then, we only have 2 minutes left, so I'm going to let Dominic kind of wrap up with some kind of final advice to our members. Especially we hear the perennial complaints of being undercut by China. We're dealing with the phase 1 deal is the only one that really has gotten through during this administration when it comes to the tech transfer, forced tech transfer hasn't been really addressed yet, and other IP issues. I wonder if you just kind of want to talk in our last 30 seconds about what we've got looking in the future here. Oh, I think you're still muted. Dominic, I can't hear you. Are you? Okay. Well, why don't you wrap up then on? We'll do that.
Well, so it's interesting. The phase 1 trade agreement, which I had on my list of things to discuss, but the list was a bit too long. It does have a very lengthy IP chapter, chapter 1, which has a number of issues that are important to SEMA members. Online enforcement, offline enforcement, physical markets, border enforcement.
There are.
What's that?
are those concrete or are those aspirational? Like, I mean,
well, there's a huge range, frankly. There's a huge range. Some are relatively concrete and some are more aspirational. But what they've also done is in addition to this IP chapter, there is like a forced tech transfer chapter, which has more aspirational language, excuse me. In addition to that, there is they call it dispute resolution chapter, chapter 7, which does provide a mechanism for U.S. companies to go through to kind of complain through USTR to get their cases raised with China through this new mechanism. So again, I could happy to talk to SEMA members offline or in a different environment about that new alternative. So that is something positive. And in addition, China is making a number of changes. I didn't mention any of them because they're all draft right now, and China could change them at the last minute. And that, I mean, that's a bit negative.
But forgive us for being skeptical until it actually takes place, because
yeah, it doesn't exist.
Promise and not a lot of
even after then. So.
Daniel, I'm unmuted now, so if I could just say maybe a sentence or two. I think what you've heard about is there are a lot of pitfalls around the world on intellectual property. You also have free resources available with the IP Attachés. My advice is don't pass up good business opportunities because of concerns about IP issues. Dive into these markets, utilize the free resources that are available. Consider investing in the protection of your rights overseas, and utilize all the resources that you can through your attachés to find guidance to navigate those IP systems, and then hopefully you'll have great business opportunities in those markets.
That's a perfect note, Dominic. I mean, this industry is, it's an American industry, the specialty aftermarket, but there's so much growth internationally, and so many companies can find these markets, and they should, work these markets in a way that they're also protected. And I think that's a perfect note to end this on. So I thank you all. The amount of collective knowledge on this panel is extraordinary. All of you, Daniel, Dominic, Peter, John, Conrad, Duncan, it's just fantastic. This webinar will be recorded, so I think it'll be available, and we really appreciate everyone who attended. So thank you very much.
Thank you.
Thank you.